Well, I am here today with Michael Hurley. He is the Government Affairs Counsel for the Foundation for Individual Rights and Expression, better known as FIRE. Welcome and thanks for talking with me.
Yeah, my pleasure.
Can you just tell us, I'm a card-carrying member of the ACLU, but for people who aren't as familiar with the civil liberties work of FIRE, can you tell us just a little bit about what your work involves?
Yeah, so FIRE is a nonpartisan nonprofit organization dedicated to protecting the First Amendment rights of all Americans, regardless of viewpoint, background, anything else. We have been in operation since 1999. For a long time, we were focused specifically on higher education, but a few years ago, we expanded off campus, and now we deal with all sorts of First Amendment issues. My focus at FIRE is specifically on higher education still, hence why I put together that write-up of all these bills in Iowa. But yeah, that's a little bit, that's what FIRE does.
Yeah, and for some of my readers, they may be, if they're thinking, where did I hear about FIRE in the news? FIRE is actually representing the former Des Moines Register pollster Ann Seltzer in that lawsuit that was brought by President Trump and other politicians. So that may be why it sounds familiar. But let's talk about higher education. First of all, before we get into the specific bills, where do you see the Iowa legislature's action in this higher education area? Is it pretty similar to what's going on in other Republican controlled states, or is it noticeably different in some way?
It's pretty common these days for legislatures to focus on diversity, equity, and inclusion. Obviously, especially Republican legislatures, that has been a major issue for them. And I think Iowa is not alone in seeking to uh, reform the way that DEI is included in higher education. Of course, the variation often comes with what does that actually look like in practice? Some states have stuck uh, pretty well to DEI offices, affirmative action, things like that. Others have taken steps into regulating what can be taught or discussed in the classroom. And so that's a key distinction we see in a lot of places, but certainly Iowa isn't alone in thinking about these issues.
And does fire get involved in some of the lawsuits or the bills that are related to just DEI offices, or is your concern more about the bills that would regulate what can be taught in the classroom?
Our focus is primarily on the free speech and academic freedom side of things. So, yes, what can be taught in the classroom? What can student organizations say? Because sometimes we see these DEI bills are a little bit overbroad in that they would restrict the ability of student organizations to advocate for diversity, equity, and inclusion. So that's usually where our focus is. We don't take a position on the broader issue of DEI offices.
hmm So let's talk about the statement that you recently had about three of the bills that are under consideration in the Iowa legislature, and one of them was just approved by the Iowa House this week. So let's talk about this House File 2487 and why it was concerning for fire.
Yeah, so this bill, among other things, requires the Iowa Board of Regents to conduct a review of all undergraduate general education requirements and core curricula, um, to basically to direct those institutions to review and identify any required courses that include, and that's a key word, include diversity, equity, inclusion, and critical race theory related content. And then once those are identified, the board has discretion to direct an institution to eliminate a course or course requirement that falls under that ambit. So the issue there, it's not that the state doesn't have some authority to reform the general education curricula at its public universities. So the state can, for example, say that we're going to require all of our students to have completed a math course or an American history course. But there are still limitations on that authority, and the big term I would use here is the state can't do anything that would cast a pall of orthodoxy over the classroom, the public university classroom. That comes from a Supreme Court case called Cation v. Board of Regents in 1967. It's one of a handful of cases where the Supreme Court has addressed academic freedom, and essentially what it's been interpreted to mean by a great many lower courts. Along with the other case law, is that the state can't say these topics, these ideas are off the table for discussion in the classroom. And so these bills, we think, cross that line by singling out specific ideas and saying that merely their inclusion in a general education course means that they need to be singled out, identified, and potentially put on the chopping block. And I think the message there is fairly clear. So that's the main issue here.
How would you respond to the floor managers about this bill have said that this isn't banning all classes. They could still offer electives on some of these topics, but they just don't want this to be part of either any required class or part of the core curriculum that students can take to satisfy a requirement.
Well, it's certainly worth noting that this bill does not preclude them being included as electives. I think that's notable. It's significant. Nevertheless, what this bill does is once a class is approved, professors need to be thinking about, okay, let's say you're teaching an American history course and you're getting into the civil rights movement. What are you allowed to talk about? What aren't you allowed to talk about? There's a pre-existing definition of DEI in Iowa state law. I'm not 100% sure that it applies in this context. There's no definition for critical race theory in Iowa law.
Mhm.
Critical race theory is generally about power dynamics in institutions, and obviously that was what the civil rights movement was all about. So
Mhm.
it's difficult, I think, for a professor to know what ratings can I assign, what can come up in class discussion, when do I do something that subjects my course to this review requirement and potentially causes it to be eliminated from the general education curriculum. So that's always a red line is when you're getting into that territory of singling out disfavored ideas and saying you can't include this content in your course.
And I tried to ask after both the Iowa Senate and House subcommittees on this bill, which I attended, I tried to ask what I took a course in college on American women's history, and many universities offer a course in, let's say, Black American history. Would a course like that be allowed as part of the core curriculum to satisfy a history requirement, or would that be excluded as DEI? And I couldn't get a straight answer. I mean, you've read the Iowa legal definition of DEI. Do you think that just even a course on, let's say, American women's history, would that fall under this kind of a bill that you couldn't have that as part of the core curriculum?
It certainly might. And I think we have generally seen schools over comply with these sorts of bills, not under comply.
Hmm.
I cited an example in my blog at Texas A&M. We saw a professor was told to remove Plato from his Intro to Philosophy course because of restrictions on, I think it was teaching gender identity and some other things like that. So, that's generally the way these things go is institutions do not interpret them narrowly. Of course, it's important to note that the First Amendment applies regardless of what state statute says. So, institutions are still barred from taking actions against professors merely because they talk about a particular educationally relevant idea during their class. Um, but I think it's hard to know exactly how these bills will be interpreted, but I think the danger again is that they're generally interpreted too broadly, not too narrowly.
Another bill that Fire expressed concern about, House Study Bill 718, it would require teacher training programs to eliminate any instructional framework that includes or is derived from concepts such as DEI or multiculturalism. So, can you take a minute to just say what's concerning about that? This is about teacher training.
Yeah, so it's a lot of the same concerns that I cited about the last bill. They also apply here. Of course, the state does have significant authority over the certification requirements that it will impose on its teachers. You need to have a bachelor's degree. You need to be trained in X, Y, or Z skills. You need to pass this certification test. Those are all perfectly legitimate things that the state can require. But again, once they get into that territory of saying, if this is a class in a teacher training program, you can't talk about X, Y, or Z educationally relevant idea. And here the focus is on pedagogical frameworks that are derived from DEI or multiculturalism. Um, if the state is saying you can't include those things in instructional materials and in discussion and a wide array of materials, you're crossing that line again of saying these ideas are not okay for discussion, and you're getting into that territory of casting a pall of orthodoxy over the
Mhm.
classroom.
And then the third, there are companion bills in the Iowa House and Senate. These would require Iowa's public universities to prohibit anti-Semitism, and then using a specific definition that's from the International Holocaust Remembrance Alliance. I would just say, as a Jewish person myself, that a lot of Jews disagree about which kinds of statements constitute anti-Semitism. But can you explain what's FIRE's interest in bills like this?
Yeah, so our interest, as with any bill we engage on, is on the free speech side of it. So here, these bills are broad enough that they will restrict constitutionally protected speech, and they will do it in a viewpoint discriminatory way. So, as to the headline here, just prohibiting anti-Semitism, I think almost everyone agrees that anti-Semitism, other forms of bigotry, these are negative things. But despite that, the First Amendment, it doesn't have an exception for hate speech. It doesn't have an exception for bigotry. Its exceptions are limited, narrowly defined to things like true threats, incitements, not just this speech is hateful. And the reason for that, of course, is that once the state gets into the business of saying X idea or Y idea can be punished merely because we, the state, have decided it's hateful, you've opened up Pandora's box. And so that's one of many arguments. It's one that Chief Justice Roberts made that I cite in my blog. Um, so that's point one. You can't just prohibit an idea, even if it's one that a great many people find offensive or wrong-headed. But as to the IRA definition specifically, it's vague for one thing. It's a certain perception of Jews, which could mean a million things to a million different people. And then the examples that it gives are viewpoint discriminatory. They say that comparing contemporary Israeli policies to those of Nazi Germany is an example of anti-Semitism. But of course, people compare American policy to Nazi Germany all the time. Any number of countries' policies can be compared to Nazi Germany, and that's a common thing in part because Nazi Germany is such a ever-present and universally understood um, horrible regime. And so it can be a very powerful rhetorical tool to compare the policies of one state to the policies of Nazi Germany. And you can't exempt Israel from that or any country. And of course, that will fall more, the burden of that will fall more on people who are critical of Israel, pro-Palestine, those sorts of things. So then that's just one example. There are others that are in there that I talk about in the blog.
Hmm. And I'll put the link to your blog in the show notes as well for people who want to check that out. It can, there's another bill, it wasn't mentioned in your statement. It would exclude private colleges and universities in Iowa from participating in what's called the Iowa Tuition Grant Program if they have a DEI office or if they have any DEI programming on campus. Does that raise any potential free speech concerns, or is that because it's more about DEI offices that you feel that maybe there's not as much of a First Amendment concern about that?
So there are still some concerns. I think you're right that this bill, unlike the other ones, is much more squarely focused on DEI offices and issues related to kind of conduct that fire doesn't take as much of an issue on.
Hmm.
Things like race conscious admissions, providing special benefits based on race, those sorts of things. Um, but there are a couple ways in which this bill does cross the line. And so I'll note first, as background that private universities, just like any private institution, they have their own First Amendment rights. The Supreme Court has said this over and over again. And even though this bill is only, it's not saying private universities can't have DEI offices. It's only saying that if they want to participate in the tuition grant program, they can have DEI offices.
Hmm.
Doesn't actually cure the speech issues that I'll explain here in a second. The Supreme Court has been very clear on this, going back to a case called Perry v. Sinderman. They said that the state may not deny a benefit to a person on a basis that infringes on their constitutionally protected interest, especially their freedom of speech. And so the specific speech issues here are that the bill isn't just dealing with conduct. It's also dealing with it defines DEI office to include offices that promote training, programming, or activities that are designed or implemented with reference to race or gender identity. But of course, programming designed with reference to race could include a symposium on the history of the civil rights movement,
Right.
could include, a lecture series about contemporary gender issues. Gender identity is another thing in this bill. And training, it could include an employee training on sexual or racial harassment. And so I think all of those issues here, they get at the speech rights of the private university. The private university does have a right to, it has a right to, if it wants to, put together an office that organizes programming on these issues. And the state can't say that in order to get this significant public benefit, you can't engage in that sort of speech. So that is a free speech issue.
And we'll be following that bill has already been approved by the Iowa House and it's pending in an Iowa Senate subcommittee this coming week. So I'll be covering that more in the future, depending on where that goes. Michael, is there anything I didn't ask you about this topic that you think would be important for my readers to know?
I think we've covered most of the ground here. I just would conclude by saying that as legislators set out to engage in higher education reform, which is a perfectly legitimate enterprise, there are a lot of aspects of that fire doesn't take any position on, others that we do. It's very important that they be mindful of these academic freedom considerations, of these constitutional considerations, because in the rush to engage in reform, it's possible to go too far in a way that will cast wide chilling effects that you don't quite anticipate. And that's just something we've seen a lot with these bills is universities over comply and the effects are in some ways greater than we initially expect.
Where can people find more about of your work or work that Fire is doing generally?
So you can go to fire.org. That is our website. If you search Michael Hurley on our website, I'm sure that a bunch of my articles will come up. But yeah, go to fire.org. You can sign up for our email list there and stay up to date on everything that we are doing.
Michael Hurley, thanks so much for taking the time to talk with me.
Yeah, my pleasure.